Ba boom. Ba boom. Ba boom. Ba boom. Ba boom. Do 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 do.
Yeah.
Ba boom. Boom.
Break it
Now
down.
we're jamming.
Oh,
Jamming.
yeah.
Jamming.
Mm-hmm. Let's go. Oh,
Jamming.
yeah.
Y'all, we are late because we were practicing that. Was it good? Could you
Exactly.
tell we
We
were
had to, we
practicing?
had to, we had to coordinate. Get everything coordinated. Perfect.
Oh my goodness.
Okay.
Okay.
All right. We ready to rock and roll then?
Oh, rocking and rolling.
Okay.
Yeah, totally ready. Okay.
Let's do
Oh,
it.
I have to think of a.
You do. All the pressure's on you.
Got it. Okay, ready? Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my alternate co-host, Brett.
Oh, I'm not your alternate co-host, Alice. I'm your always co-host. What are you trying to say? Are you trying to tell me something? Am I being fired? I feel like I'm being
Well,
fired.
this is an awkward way to say you're being replaced. Just kidding.
Mm.
Sorry, Brett, but sometimes you are the alternate co-host. Sometimes I'm the alternate co-host, but that doesn't really mean anything because we're always on the podcast together. But what does it mean if you want to say there's an alternate suspect for the crime that you've been indicted for?
Yeah, Alice, and this is sometimes called the "some other dude did it" defense. A very popular defense out there, and one of those things that comes up a lot, and you hear about it a lot. And one reason you often hear about it is because you'll see when someone's convicted, there's a claim of, "Well, I had an alternate suspect, and I really wanted to put that person forward. And if only the jury had heard what I had to say about the other guy, they would have acquitted me. But the mean, evil judge, he was clearly in the pocket of the prosecution, wouldn't allow me to introduce that evidence." And we thought, hey, this is a topic that almost no one knows anything about. So why not talk about it, particularly because it is going to be an issue likely in the upcoming Delphi trial, as it's not just some other dude did it, it's some other cult did it, is what we've heard from the defense continuously now, going on 7 or 8 months, and even in their latest filings, talking about Odinist. And this question of what is the defense going to have to show in order to make the Odinist argument, not just to the public, but to the jury?
Ready to jump into this because, you know, you hear this talked about all the time. Just like Brett was saying, we hear all the time, oh, they weren't allowed to present this or what. Or those who worry about some sort of filter or sieve says, what keeps someone from just saying that guy did it? So everyone's going to have an alternative suspect defense. You know, how do we even begin to suss out what has evidentiary value to be presented at all? Lucky for you, we've done our research so that you don't have to. And after this, you're just going to be able to know left and right what should be let in, what should not be left in. Spoiler alert. It's fact specific. It's fact specific.
Yeah, as is so many things when you talk about the law. And I think it's important for everybody to remember, and just to start off with this basic premise, the legal system is supposed to be fair to both the prosecution and the defense. We focus a lot on fairness to the defense, and that's important, and we should, because we want to ensure that defendants receive a fair trial and that all their constitutional rights are honored. But I think it's important to remember that a defendant's constitutional rights come from the amendments to the Constitution, because the Constitution was created to provide, as it says in the preamble, justice and to create a justice system. And both sides are supposed to receive sort of a balanced approach from the courts. And that's one reason, for instance, that the rules of evidence apply pretty equally to both sides. There are a few rules that benefit the defense a little bit more than the prosecution. If you followed all of our hearsay episodes, there were a few hearsay rules, for instance, that only applied to the prosecution. But for the most part, the same rules that apply to the prosecution when they're trying to put evidence in apply to the defense when they are trying to put evidence in. So that is going to apply here. Now, we start, because this is an affirmative defense, the defense wants to put it on, with the Sixth Amendment. And the Sixth Amendment has long been understood to protect a defendant's right to present a complete defense to secure a full and fair trial. Now, when we say complete defense, that doesn't mean that they get to say whatever they want. It means any defense within the rules of evidence that they want to present, they should be able to do so. And one of the basic components of that right is the right to present evidence. In this case, evidence that someone else might have been involved in the crime. But in Indiana and in every state, quote, a criminal defendant does not enjoy an unlimited constitutional right to offer exculpatory evidence. And that's from Hubbard v. State, which is an Indiana Supreme Court case. And we're going to talk a lot about Indiana cases because we're just going to view this through the lens of Indiana because of Delphi. But if you look in any state and in the federal government, you'll see a lot of cases saying very similar things. At the end of the day, this is pretty much a constitutional question. So you see a lot of uniformity across the states, though, as we've pointed out before, not total uniformity.
And that's so important, what Brett just read from Hubbard v. State. A criminal defendant does not enjoy an unlimited constitutional right to offer exculpatory evidence. Because already, especially in the Delphi case, I've heard they should have an unlimited right to say whatever they want against gag orders, against X, Y, and Z. They should do whatever they want to present the most vigorous defense. It is unanimous across our justice system in America that that right has limits, and you'll see why. Now, of course, where that line is kind of the devil's in the details, and we'll get into what these cases say about it. But hear that. So whenever you hear someone on TV tell you they have an unlimited right, they can do whatever they want to present the most vigorous defense, that is incorrect under our Constitution. So one of the premier cases on this question in Indiana is also a famous one. You may have heard about it before, but it's the Pelly family murders. Jeff Pelly was convicted for murdering his family so that he could attend his high school senior prom. This crime occurred in 1989, but he wasn't convicted until 2006. So, among other things, Pelly sought to introduce evidence that it was his father who had been involved in money laundering, and that was the real motive for the murder. Now, Pelly wished to offer the following evidence to the jury. One, before, and this is straight from the Indiana Supreme Court opinion, Pelly versus State. One, before the family moved to Indiana, $1 million in cash was missing from the bank. And Bob, who worked at the bank, is his father, was called in to work in the middle of the night. Number two, Bob was responsible for finding the missing money and was in charge of the computers at the bank. Number three, what Pelly sought to introduce as evidence. After this incident, the family suddenly moved to Indiana. And four, the DEA closed the bank in March 1990. So this case is Supreme Court case from Indiana in 2009. Now, the trial court excluded this evidence that Pelly wanted to admit at his murder trial. And they said, quote, it was too attenuated because it leaves utter speculation. As you can see, I mean, that was kind of just like, you see what story he wants to tell, but there's no kind of final evidence that brings it all together. What does this money, this bank closing, there's not even a tie with his dad to the bank, much less a tie to a money laundering, much less to the money laundering tied to someone who wants to murder the whole family, who is not Jeff.
And you can see how this is the kind of thing that's popular fodder for like a podcast, right? I mean, we would talk about this if we covered this case, and maybe one day we will. But we would talk about the sort of alternative theory that there's this money laundering thing going on, and somehow that's the reason. You know, it's not because, frankly, we always talk about motive. Killing your whole family so you can go to prom seems extreme to most people. I mean, I had a case once where a guy killed his whole family because he wanted to go see Scream, and his dad said no. So he murdered the whole family and then went to go see Scream. So it's not as if these things don't happen, but the sort of $1 million missing from the bank, his dad's somehow involved. You know, he's fleeing to Indiana to avoid this. The bank's getting closed afterwards. You know, it's a much sexier theory in some ways, but it's also more, people can grab onto that. You know, people can understand that better than they can kid kills his family to go to prom. So you can see why it would be popular in a podcast, and you can see why the defense would want to introduce it. But the trial court says no. So then it goes to the Intermediary Court of Appeals, and the Court of Appeals reverses, and they say, trial court got it wrong. Should have let this in, reverse the conviction, let's try it again. But then it's going to go up to the Indiana Supreme Court, who's going to take up the case, and they are going to talk about this. And this is going to become one of the most important cases in Indiana on this whole question of when you can offer third-party motive. So the court, first, it notes that the evidence of a third party motive, the some other dude did it defense, is relevant under the rules of evidence because it makes it less probable the defendant committed the crime. But that's Rule 401. And as we said in some of our prior legal briefs, when we talked about the rules of evidence, Rule 401 is a very low bar. It is not hard to cross the relevance bar. As the Supreme Court says, all you have to do is show that this evidence somehow makes some fact more likely. It doesn't even have to be the key fact. It doesn't even have to be, for instance, in this case, I mean, that's a key fact, whether or not he did it, but it can be pretty much any fact. So you have to show it's relevant. I mean, that's the first thing. If you can't show it's relevant, it doesn't come in. But relevance is pretty easy to get over. But relevance is usually not, well, it's almost never the last rule you're going to have to get by. The rule you often have to get by, and a rule we've talked about a lot, is Rule 403. And Rule 403 is one of those rules. I mean, it says a lot of things, but what it says is the evidence has to be more probative than it is unfairly prejudicial. And there are a lot of reasons it could be unfairly prejudicial. It could be cumulative. It could be confusing. It could be prejudicial just because it goes to unfair character evidence. Like all that sort of stuff is a reason you might keep something that is relevant out from getting in front of the jury. And so when the court looked at this, they really focused on 403, and they said that alternative suspects can be excluded if, quote, its probative value is outweighed by unfair prejudice, confusion of the issues, or the potential to mislead the jury. And it quotes a United States Supreme Court case. And as the Supreme Court explained, and as the court quoted, frequently matters offered in evidence for this purpose are so remote and lack such connection with the crime that they are excluded. Such evidence may be excluded where it does not sufficiently connect the other person to the crime, as, for example, where the evidence is speculative or remote, or does not tend to prove or disprove a material fact at issue at the defendant's trial. And that is a case called Holmes versus South Carolina, the 2006 United States Supreme Court case. So the Indiana Supreme Court, looking to what the United States Supreme Court has said before, says, look, fine, it's relevant, but what you really have to show is it's not so speculative that it's just going to confuse the jury, and you really haven't formed an evidentiary basis where you can bring this in. And if you can't do that, we're not going to let you bring it in just because you've come up with a good theory.
So in Pelley, the Indiana Supreme Court gave some examples of when this evidence is appropriate and when it's not, because it's really in applying it that all the questions come up. So in Sturt, I was telling Brett before I got on, I was like, the weekends are tough, man. You're like with your kids all day and it's awesome, but exhausting. So I popped not a couple of uppers. I just popped a couple Dove chocolates, but they haven't hit yet. So
Alice's meth is chocolate.
Oh, so good though. Dark chocolate with a little almond in there. Okay, sorry. Sturt. I meant to say state. In Pelley, the Indiana Supreme Court gave some examples of when this evidence is appropriate and when it's not, because it's really when you apply it that the devil's in the details, and that's when the rubber meets the road. All those other similes, analogies. So in State versus Joyner, the Supreme Court reversed when a lower court excluded a third-party theory. Here's what the defendant offered in that case. Quote, the defendant wished to present evidence that a third party was having an affair with the victim, worked with the victim, had engaged in sexual relations with the victim the day before her disappearance, had argued with the victim the day of her disappearance, and had been tardy to work and falsified his time card the day after the disappearance. The defendant had already presented expert testimony that a hair sample found inside the plastic bag covering the victim's head excluded the victim and the defendant, but was a 98 to 99% probability match to the third party. So that's a strong argument to present evidence of another suspect, I would think. And honestly, I'm surprised that the trial court would exclude something like that. You can see how earlier we talked about the money laundering case, kind of not pulling it around. Here we have someone who intimately involved motive, access, and then actual DNA evidence tying them to the inside of the bag that's suffocating the victim. And the trial court said, no.
Sometimes I feel like trial courts mess something up just so spectacularly, just so the court can have a really good example.
Good facts. So we talk about this, good facts make good law. Sometimes you need such a textbook example that all legal, all law students are like, of course this should be let in.
I mean, maybe something was going on in State versus Joyner that I don't know, but this is like the judge should just resign, like, because this one is so
The hair inside
yeah,
of the
yeah.
murder weapon, feels pretty
When
tied up.
it's like when, if you were the judge in this case, would you let in a third party? Does the guy have to be on video doing it? I mean, I'm not certain where that person drew the line. But nevertheless, it is a great opportunity for the Supreme Court to essentially, here's the polls on this, right? So this one is obviously, this should have been allowed. There's a great story you're telling, backed up by forensic evidence. This is something that you should be able to bring in. So what they're going to do is then they're going to say, okay, so that's the case where it obviously should have gone in. Where's a case that it really shouldn't go, right? And they talked about a case called Lashbrook. So in Lashbrook, the defendant had evidence that another party had said the murder victim was, quote, going to die. Now, despite this connection to the victim and the murder, the court said this was too speculative because, quote, the defendant presents no material evidence that the person was connected to the crime. So, and that might be surprising to you. There is someone who said, this person's going to die. And the court was like, not good enough. Can't bring that in. And we talk about, the more you learn about the law, I think the more you understand cases and weird things that happen. You remember Adnan? I'm sure you guys all remember about Adnan, and there was that whole question of whether or not certain things were Brady material because it was so exculpatory that obviously there should have been a new trial. One of them was, and when we looked at it, we didn't even think this was true, but just taking it as charitably as possible, one of them was that someone else had said something about how Hae-Min Lee was going to die or he was going to kill Hae-Min Lee or whatever, and that was one of the big facts. Well, in this case, you have exactly that. You have someone saying that the victim is going to die, and the victim then dies, and the court says, sorry, that's not good enough. You need more than that. You need more than saying something like that in order to bring this in. You need something else that connects this person to the crime. And that may be surprising to you, but this is actually a pretty high bar. And what we're going to see as we look through this is courts are constantly swinging between these two extremes to try and figure out whether evidence should come in or not. And the court in Pelley's case concluded that it was closer to Lashbrook. And here's what they said. Pelley suggested that someone from Bob's past in Florida had the motive to commit the murders. Pelley's offer of proof was hearsay statements of Jeff and Jackie that Bob had worked at a Florida bank connected with money laundering, and hearsay within hearsay that a limousine with Florida license plates was seen near the Pelley's home on the day of the murders, because every time there's a murder, there's always some suspicious vehicle seen outside the home, right? So, of course, that happened here too. However, Pelley did not show how he or Jacques was competent to testify regarding the Florida situation. Equally important, he failed to present any evidence connecting the bank or the limousine to the murders. Absent a more direct connection, the trial court did not abuse its discretion in excluding this evidence as too speculative. Now, Pelley case is ongoing, and there's been stuff back and forth, but on this narrow question of sort of the third party liability, the court basically said, yeah, the trial court got it right. That was too speculative. You had some good information, but it just wasn't good enough. Didn't have to come in.
So we've kind of seen the different fact patterns in these couple of cases. And here's the thing. When you're doing legal research, anyone can do it. Legal research is doing exactly what we're doing here, reading all the different fact patterns of the cases and seeing how the courts applied those facts to the case and finding your most similar fact pattern. And so you don't stop at 2 cases. You look at as many cases as possible when you are trying to figure out your legal argument. So here are some other fact patterns where the Indiana courts have upheld a decision by the trial court to exclude alternate suspects. Stevens versus State. So in the present case, Stevens sought to admit into evidence text messages between Gould and Lewis that Stevens allegedly showed that Gould and Lewis had a contentious, controlling relationship, and they were arguing just hours before the murders occurred. Stevens wished to admit this evidence to show that Lewis could have been an alleged third-party perpetrator of the murders. Stevens made an offer of proof that consisted of the text messages, and after argument by both parties to the judge, the trial court determined that Stevens had failed to demonstrate a connection between Lewis, the alleged third-party perpetrator, and the murders. The text messages between Gould and Lewis merely showed that the two had a conversation during the hours before the murder occurred. The text message conversation ended several hours before the murders happened and did not provide a connection to the time that the murders took place or any connection whatsoever to the murders themselves. Now, think about what that means. So essentially what this fact pattern is, the defendant wanted to show text messages of someone else talking to the victim. And he's contending that that conversation was an argument, so motive that he would kill him. And the judge saw the text messages and essentially says, no, all you're showing here is that this third party, the alternate suspect, had a conversation that ended hours before the victim's murder. And you can imagine why that's important here, because in our very connected state today, we text, we Snapchat, we are commenting on people's Facebook posts, whatnot. We're in constant communication with a lot of people. If the bar was simply that you were communicating with someone before they were murdered, that could introduce a whole lot of alternative suspects that may not actually have any evidentiary value to lead to them being the third-party perpetrator. You need to show something more than just you had contact, electronic contact at that, with the victim hours before their demise.
So this next one's going to blow your mind because, once again, I think most people think the baseline is you suggest somebody else did it, it comes in. That is definitely not the case. And this one is one where I'm surprised it went the way it did, but this just goes to show how high a bar this is. This is Tibbs v. State. So I'm going to read to you from Tibbs v. State. These are all Indiana cases. Tibbs first contends the trial court denied him his right to present a complete defense by excluding testimony that McCarty was indicted for Rison's murder. So Tibbs is accused of killing Rison. So he wants to show that McCarty, before he was accused of doing it, was actually indicted for the murder. Rison's 1989 statement that McCarty threatened to kill her if she disclosed that he sexually abused her. So now we have McCarty sexually abusing Rison, and we have Rison, who is the victim, saying that he threatened to kill her. Statements that McCarty asked Lori to clean out his car. So, trying to cover up the fact that he did it, right? And the details of McCarty's inconsistent statements regarding his whereabouts the night Rison disappeared. Tibbs contends this evidence tends to show that McCarty murdered Rison and that its exclusion was not harmless error. So this seems like a pretty solid some other guy did it defense, right? There's a connection, a very clear connection between the some other guy. He is accused of sexually abusing the victim. Oh, and by the way, we have a statement from the victim, sort of beyond the grave, that he threatened to murder her if she disclosed that he sexually abused her. His statements about where he was that night were inconsistent. He's asking someone else to clean out his car. And oh, by the way, the state was so convinced that he did it that at some point they indicted him. Here's what the court said. We conclude the evidence Tibbs sought to introduce, that McCarty was indicted for Rison's murder, that in 1989, Rison reported McCarty threatening to kill her if she disclosed he sexually molested her, that McCarty allegedly asked Lori to clean out his car, and the details of McCarty's conflicting statements related to his whereabouts around the time Rison disappeared was neither sufficiently exculpatory nor relevant evidence of a third-party perpetrator. None of the excluded evidence made it less probable that Tibbs murdered Rison or that McCarty was responsible for her murder as required under Rule of Evidence 401. So there you go. Now look, some of this is going to be the weight of the evidence against the person. So, that's part of it. If there's a ton of evidence against you, the likelihood you're going to be able to bring in the some other guy did it defense is going to be much lower. And maybe that's what happened in this case. But it certainly seemed like Tibbs had a pretty good argument. If he was going to be able to make this, he had a pretty good argument for why he should be able to make it.
And something that's like kind of coming up, and this is what you're always supposed to be doing when you're doing this legal analysis and how it applies to your case, is you have big general theories that could apply to anyone, and then victim specific theories, right? The generally, this person hated all 12-year-old girls versus this person had a secret online relationship with this girl and had access to her in a way that no adults knew in her life. So she was vulnerable to it. So think about what that is. Think about the Odinism theory, for example. Is it like all Odinists are part of the theory, or is there something specific about Odinism and the alternate suspect? They have to hone this. If they want even a chance of getting this in, they need to think about it, because you can't just throw out a massive theory. Look at this case. I mean, the McCarty case. I mean, that's the Tibbs case. I mean, that's like honing in on the specific person and their relation to the victim, and it was still excluded. So let's keep going. Moore versus State. We're here all day with cases for you. Moore argues that the trial court abused its discretion in excluding Snow's and Bourne's testimony, arguing that the testimony would have demonstrated Snow's potential third-party motive to kill Alice. Not this Alice. While it is undisputed that Snow talked to police on the day that Alice's body was discovered, at the time he indicated that he was sharing information that he had heard from others. Police also determined that some of the information provided to them by Snow was inaccurate. Furthermore, while Moore argues that Bourne's testimony would have contradicted Snow's assertion that he had not committed the murder, the trial court found that Bourne's testimony was not sufficient to create a link between Snow and the crime, given the other evidence establishing that Snow had an alibi for the date on which Alice had been killed, and that he had been excluded as a potential source of the DNA recovered from Alice's body. It's kind of bottom line conclusion there. Even if it looks like it's a viable or maybe a good theory to put forth for the alternate suspect, if the investigation had excluded them definitively for, like, he has a rock solid alibi, there's no other way that he could have committed this crime, that's going to factor into the court's analysis as to whether the alternative suspect can come in as evidence.
And it's hard not to read through these and not think about the Odinism thing. Obviously, the defense may have a more sophisticated argument for Odinism than they did when they initially discussed it, but you may recall that their chief suspect was at work that day and has an alibi. And they basically speculated, well, maybe one of his cult members did it for him while he was at work. And, maybe he met them afterwards and that's what happened, right? That's going to be a problem. If the person has an alibi and you're just having to speculate about what might have happened, that's an issue for you when you want to offer that person as an alternative. And I think, we've talked about it as the Odinism theory, but it's not just random Odinists did it, as Alice pointed out. You're trying to say the specific people did it, and you're going to have to give some sort of basis to believe that other than you came up with the theory. You're going to have to show some specific connection. And I think that's one thing that's important here. Something that's lacking in a lot of these cases is a specific connection between the person who is the third-party entity and the crime itself. So even if you have motive, even if you have a connection between the victim, even if you have evidence of some hostility, I mean, you're seeing people threatening to kill somebody. You're seeing people have real violent connections between the victim, and yet it's still being excluded. We'll look at one more case, Sterling versus State. And one reason these are all affirming is because it was really hard to find a case that overturned a ruling by the trial court that you could not let this in. We talked about one. It was sort of the prototypical case. But other than that, most of them are coming out this way.
And I think this makes sense, right? We've talked a lot about this, where oftentimes, at least in my experience, it's going to be judge specific, but judges tend to err on the side of giving more leeway to letting the defense present the defense that they want. I mean, there are arguments that I've seen where I'm like, oh, that's not the greatest. But so to keep something out, typically, I think is something that the trial court really, really grapples with, because they recognize, first of all, it's going to be appealed. And they also want to make sure that the defendant gets a fair trial.
So now we're going to talk about Sterling versus State. Sterling's proposed theory of the defense relating to another suspect stems from an instance involving Tommy Warren. In 2003, Dwayne was charged with attempted murder of Warren. However, the case was ultimately dismissed. Sterling contends that Marie could testify to witnessing some type of stare-off between Warren and Dwayne in 2006. When Dwayne asked Warren, "Do you got a problem with me? If you do, take it out. We'll settle it in the streets," or "take it out in the streets." Sterling also notes an officer at the scene of Dwayne's murder reported that he overheard a female say that Warren did it. To further promote the idea that Warren is a suspect, Sterling directs our attention to a single Crime Stoppers tip after Dwayne's death that listed Warren as a suspect. The defense in this case subpoenaed Warren, and he refused to testify, citing his right not to incriminate himself under the Fifth Amendment to the United States Constitution. So there you go. So you've got previous beef between Dwayne and Warren. Dwayne's the victim. Dwayne got murdered. The state is saying Sterling did it. Sterling's saying, no, it was Dwayne. Basically, for at least 3 years, Dwayne and Warren had this argument going back and forth. In 2006, you've got some sort of public altercation between them where Dwayne says, if you got a problem with me, we'll settle it in the streets. You've got a person saying that Warren did it. An officer, I guess, who can testify that he overheard someone say that Warren did it. You've got a Crime Stopper report that says Warren did it. You got Warren saying, I'm not going to testify. I'm going to assert my Fifth Amendment right to not testify. So does all this evidence come in or not? Here's what the Indiana court said. Here, Sterling fails to present material evidence that directly connects Warren to the crime, instead presenting us with unfounded and speculative information. An anonymous woman overheard saying Warren did it. A Crime Stoppers tip. Consequently, the trial court did not err in excluding this evidence. So once again, if all you have is speculation, even if it's speculation founded on something, you're not going to get there. You have to have something tying the people that you're seeking to connect to the murder. There has to be something direct. You know, one of the things they talk about and they compare, they're constantly going back to this one case. Go back to see which case that was. So it wasn't Pelly, it was the other one. In the state versus Joyner. So they're constantly going back to state versus Joyner to sort of explain why is this different from state versus Joyner. And one of the things they talk about a lot is the DNA, the fact that there was actual forensic evidence at the scene that somehow tied this person to the case. And you gotta wonder if they hadn't had that, if all they'd had, and just to go back to the facts of that case for you, because like I said, we've done a lot where it didn't come in. So the defendant wished to present evidence that a third party was having an affair with the victim, worked with the victim, had engaged in sexual relations with the victim the day before her disappearance, had argued with the victim the day of her disappearance, and had been tardied to work and falsified his time card the day after her disappearance. So a bunch of stuff happening with her right around her disappearance. I'm not sure if that's all they had if it would have come in, just based on the cases we've seen. It might have because it's so close. There's stuff that's very close to the murder and on both sides of the murder happening that's suspicious, but I'm not sure it comes in. But because they had the forensic evidence, they had the DNA evidence that also connected, then that sort of put them over the edge. So without that, it's a close case. With that, I think it's an obvious case. And what you see from these other cases is that unless you have something like that, something specific connecting the person you want to point to the murder itself, not just to the victim, not just to the situation, but to the murder itself, it's probably not going to come in. And I think this is about to get very relevant in the Delphi case.
Yeah. And also, I think something else that's going to become relevant, we don't know the facts of it, but it'll be interesting when they have to duke it out in court, if they have to duke it out in court, is whether an investigation cleared that person with an alibi. And there was, so this goes along with what you just said, Brett, of tying that particular alternative suspect to the murder scene and the murder victim at the time of the murder. But we'll see here. I mean, here's the thing. It is, if you learn nothing from this episode, know that you do not have an unlimited right to just spout out theories however you want them, even if you think you have evidence of it. That is something that has to be presented to the court first. And based on the cases we've seen in Indiana, and also these Indiana courts, by the way, are very similar to courts across the country. It's a bar. It's certainly not a low bar. And you can understand why. There is a person on trial, and the trial is for that person, that there's a real alternative suspect The courts will grapple with it and allow that evidence in. But this is not your opportunity to essentially filibuster with whatever evidence you want or whatever theory you want ad nauseum, because that doesn't bring justice for that defendant or for the victims in that case.
And I think, this trial supposedly is going to happen in the middle of May because the defense has exercised its right to a speedy trial. We will see whether or not the defense unexercises that right at some point and decides, actually, no, the voluminous discovery and the prosecution, they just give us everything so late. And however, this could we ever do this? They're violating Richard Allen's rights again by not giving this evidence in time. So unfortunately, as much as we hate to do it, we must ask for continuance. We'll see if that happens. I think that's likely. If it doesn't happen, then I would expect in the next couple of weeks, the prosecution is going to file a motion in limine to exclude an motion in limine is something you file before the trial where there is sort of a complicated issue. I mean, not everything, in the movies, everything is handled by objections on the fly. In reality, almost everything is handled with things that happen before the trial. Motions in limine or motions to limit what comes in. And a lot of them are pretty standard, but every now and then you'll have one to a specific issue. And I think you'll see the state file a motion in limine to exclude the odinous theory from the case and say that the defense can't put it on. And I think a less bold judge, maybe a more careful judge, might deny that motion just because there's so much focus on this. Judge Gold seems like the kind of person who's actually just going to adhere to the law and not make exceptions because the case is particularly contentious, unless the defense has something else than what they've shown up to this point. And what they've shown up to this point is just bare speculation. There is some connection to one of the girls for one of the people they've accused of being an odinist.
I mean, I will say this. It's based on the case all we've looked at today. It's not going to be enough that you have some sort of Odinism patch and that you walk around the town of Delphi.
Yeah, they're going to need a lot more than that. And frankly, I think if the prosecution files that motion, which I think they will, I think it will be excluded. And the weeping and the gnashing of teeth that you will hear when that happens you will be able to hear it on the moon. But based on the law, unless they have more, it should be excluded. It shouldn't come in because it is speculative and it is confusing and it will distract the jury from the actual evidence in the case if you have the defense talking about Odinist every 5 minutes. So that will be a really interesting fight. It's one that I think will come very soon and we'll just have to see. And I think it's one of the reasons, thinking about the defense's mindset, you guys all know the defense wanted that they filed that weird motion for a parody or whatever they called it, where they wanted money for experts, but they didn't want to do it the way everybody else does it, which is you submit to the court sort of a document that says, hey, this is the expert we want. This is what's going to cost, an invoice, essentially. This is what's going to cost. This is what it's for. This is why we need it. They don't want to do that. They want to be able to hire the experts, get their report, and then submit a bill to the court, which will be paid without question. That's essentially what they want. They don't want to submit the invoice. Well, the reason they don't want to submit the invoice, I think, is because presumably some of those experts they want to hire are Odinist experts, experts on cults, experts on human sacrifices or whatever. If they ask for that up front, it initiates this fight. Once they ask for that, the response to the prosecution is going to be, look, you want an expert on ballistics? Great. That makes sense. You want an expert on false convictions? Makes sense because you guys confessing everybody under the sun. You want an expert on Odinist? No. You should not get that because you haven't shown a basis for why you should let that in, any more than if you wanted to hire, one of the ancient aliens guys to say it was aliens who did it. No, we're not going to let you do that. It's a waste of money. It's not relevant. It's obviously confusing. There's all sorts of reasons that wouldn't come in. The Odinist thing is the same thing from the prosecution's perspective. I realize the defense thinks it's very serious, but from the prosecution's perspective, that starts that fight, and then they can have that fight then. So I think the defense is trying to push that fight off as long as possible to the last minute, maybe in the hopes that the prosecution will just forget to file a motion in limine about this, and maybe somehow they can sort of get it in without ever having to fight about it. But I think that's one reason they don't want to do that expert stuff, is because they know that's when the fight will start. So it'll be interesting to see what happens. And I mean, just based on the law, I don't think it looks good for the defense.
And also, that was just a little preview of like why certain, first of all, you can't get rejected or get something you don't ask for, expert funding. But second of all, you can see why there also is not an unlimited fund of experts, because there are certain bases and constitutional barriers to what sorts of defenses you can even present. And if something is not allowed to be presented, that is wasted money, wasted public money, to be throwing money at an expert for an expert that you cannot use. So this is a lot more, there's a lot more to it than meets the eye, and a lot more than what is being told kind of in top line articles. So the more you know, right? So I hope this was helpful, because this is relevant not just in Delphi, obviously. We recently talked about the Corey Richins case, that had to do with her husband and whether he had anything to do with it. But you can see how this is going to be very attractive. And the Delphi case just has, kind of spun into all these discussions online we've seen about people saying, well, when can you and when can't you present evidence of an alternative suspect? Now, hopefully, you know a little bit more, and there will be more to talk about, especially as it gets applied to different cases that we're following. And we're always happy to answer any questions that you have. With that, Brett, do you have anything else you'd like to add?
I just wanted to come back to something we said at the very beginning, because I think it's important to remember, and that's that as this line of cases shows, just because you're on the defense side doesn't mean you get to do anything you want. It doesn't mean you get to introduce anything you want. And it doesn't mean that the only way a defendant can have a fair trial is if they get to say and do anything they want. There is, and we see it in Delphi a lot, every time the judge rules against the defense, it is a violation of their constitutional rights. Their constitutional, Richard Allen's constitutional right to defend himself has been violated because the judge wouldn't let him do X, Y, or Z. And that is just not the case. If the ruling is in keeping with the Constitution and the law, then in fact, the defendant's constitutional rights have been upheld. He didn't get to do exactly what he wanted, but his rights were upheld because he's getting what he is entitled to under the law. And just when you see the spin on it, just remember that. Look at the reasons, look at the case law. Richard Allen ended up winning on the lawyer thing when his lawyers were removed. He ended up winning that, right? That's going to happen. There were really good reasons for it. If you read the Supreme Court opinion, there were good reasons for it. As we've said, I think a lot of it comes down to the record just wasn't very well developed, but he ended up winning that. A lot of the things that he's losing are not things he's going to win. And just one tiny little thing, in case you're wondering about this, when the court excludes this, it will not be instantly appealable. They'll have to have the trial. They'll have to see whether or not he's convicted or not. Then it would be part of an appeal. This won't be like removing the lawyers. This will be something that you'll see in a post-conviction review, not some sort of interlocutory mandamus type thing. That's all I got, Alice.
That's great. That's great. Well, this is a primer. Now you know before we jump into this fight. We'll see what happens. I agree with you, Brett. I think there's no way this trial is happening in May because, first of all, the defense just hasn't done all of the work that it needs to do leading up to trial. None of the motions they filed, for example, if you want to present this sort of defense, you need to do more than just assert in a Frank's motion that has since been denied. So there's a lot of work to be done. I don't think we'll see a trial in May, but we certainly will see this issue crop up in this and probably many other cases.
Just one other thing. Sorry, I keep coming with these.
Yeah, go for it.
By the way, the excuse, if you're wondering what the excuse will be about why we need to continue the trial, it's probably going to be mental health. I think the defense has set up in some of its recent filings that Richard Allen's mental health is deteriorating because he's being tortured in the prison. And so I think what they'll say is we have to get some sort of mental health evaluation of our defendant. Unfortunately, as much as we would love to try this case in May and really wanted to, the evil, Odinist guards have driven our client crazy and he needs some sort of mental evaluation. I think that'll probably be the excuse. It's a pretty good one. Almost certainly
because
will
you
be
can't
granted.
move forward, right? You
Right.
can't. That is one thing you just can't move forward without. And I think they will take that opportunity also to further flesh out their Odinism theory about that, how that has to do with his mental deterioration as well. So I will see how it plays out, but I think it'll play out very soon because it has to. Well, we'll see. And we are always happy to be wrong because you know what? I want this case to go to trial if that's where it's going, if he doesn't plea out, because the longer this goes on, the greater of a circus it's become. And people who should not be benefiting off of this case, who are not the victims, who are not the defendant, need to go find something else to do and something else to cover. So, with all that said, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
We should have Othram on again.
I was going to say, we don't have an Othram episode planned, but we could pick one of the cases. We could do what we said we were going to do and do not, because I'm trying to think.
I think maybe next June, Joe. I think they were actually talking about next June, not this June, on Coburger.
Yeah. I think for Othram, we could have Middleman come back and talk about the law that she had passed.
Oh yeah,
let's have her, because that'll be a more interesting, rather than just repeating because I think we've talked about the actual technology before, but she can talk about the law she helped pass in Florida, and I think it's like it's in motion other places. So let's reach out to her. That way we have an Othram episode, and we
can talk about our visit and how awesome it was.
Yeah, let's do that. Thanks, guys. You helped us come up with another legal briefs.
Y'all are so good. And look, I mean, maybe the trial will happen. I will just be stunned. I mean, it's just
there's so much close. They haven't done. That's just the problem. Is like a month out from trial, and all that is left. They haven't tried to suppress the evidence yet. They haven't.
A month out from trial, you're lying.
Daubert fights, like Daubert or Daubert, as Brett says, all the expert fights. They haven't actually even started to challenge the ballistics.
Yeah, they filed like 5 Franks motions, but not like any actual suppression motions.
So they actually should be trying to suppress is the ballistic stuff, because that is like, I don't know, the markings, but it wasn't fired. Like, there is actually an argument to be made there. I don't know why they haven't actually filed those real things.
Yeah, real motions. I mean,
real motions. They're running GoFundMes instead.
Not some of the weird stuff they file where they kind of mention it offhand and it gets denied. And they're like, oh, I can't believe it's denied.
Yeah,
like exactly. Real stuff with real arguments and real citations to law.
Way,
some expert stuff and an expert report.
The reason this is frustrating as attorneys is every attorney watching this is like, you are technically, well, I think they were getting real close to those ethical lines, but there are codes of conduct for all attorneys. You carry yourself with like ethical duty in front of a court, and this is just so thrown to the wind, and it's making a mockery of the entire justice system, and it's making a mockery of our entire profession. That's why this is frustrating, because we are in the same industry as you, and you ruin it for all of us. Like, all of us are going to have to practice law differently because of you. And that's why this is frustrating, because it is not just ruining it for Abby and Libby. It's not just ruining it for Richard Allen. It is ruining it for all criminal defendants, all alternative suspect evidentiary standards that people want to be doing, because everyone, guess what? When this all goes through and like we actually can look back with calm eyes, we're going to be like, really? We bought the Odinism thing? Like, we actually had articles about this. We gave them fire for this thing. And then the next guy who has an actual theory, they're going to be, oh, what do you have, an Odinism theory? Like, this is bad for criminal defendants across the board. It's bad for victims across the board. It is bad for true crime. It is bad for judges. It is bad for cameras in the courtroom. This will be the case where all judges will look to and say no cameras in the courtroom, because psychotic circus attention-seeking documentary, chasing attorneys are going to use this to line their own pockets. That's why this is so annoying, because it is ruining it for all of us who are actually looking for justice, who are actually trying to cover the legal system, so that it's something that we all live under and we all depend on to keep the strictures of our society in place. They're tearing it down from the inside out. And it's like, you know what? It doesn't limit it to this case. This is our society. You're just taking a blowtorch to. Like, have fun. Way to like not have any foresight. So that's why we care.
Yeah.
The chocolate just kicked in, if you can't tell.
Oh man,
I don't know what was in that chocolate, but it was good.
Wow, there you go. Yeah, exactly.
This can all be edited out, Jason.
I had other things to say, but no more.
Well, no, I've been thinking about this a lot, and how you said you felt bad last time, and I was like, Brett should not feel bad about this, because that is some BS, because you're not the one who should feel bad about this, because the reason you feel bad is because what I just said, because you feel like ownership and protection over our legal system that is being literally torn down by a bunch of weenies. That's the best I can describe them as. A bunch of weenies. They're not real men. If we had women in there, this would not be happening. You know that's true. Yeah, I guess we can do questions.
Okay. You want to do?
Did I scare
Yeah.
you, Brett? I'm so sorry.
No,
I just
I mean,
scared
I feel
everybody.
like just never mind the sign off. It was a fake sign off. We were just
Yeah,
trying
the
to
fake
confuse
sign
you
up. This
guys.
was the real. Oh my
This,
God.
yeah, we just kept going.
I just like,
Okay, let's do questions tonight.
let's do questions. So Brett, before we sign up, would you like to do some questions?
Let's do some questions, Alice. That sounds like a great idea. Let's see what we got. Oh my goodness.
Anyways.
Yeah, well, it'll be over.
It won't be over. That's the problem. We could have, in a real world, we could have gone to trial already.
Oh yeah, we could have. We should have. I mean, I don't know. Sometimes I wonder if it's ever going to go to trial. Like I keep saying it's not going to happen in May, but I'm
It
like,
shouldn't go to
please
trial.
let it
That's
happen
the
in
thing.
May. Well, no, it
It
shouldn't
shouldn't go to
No,
trial.
they should have pled guilty by now.
They should have
absolutely
pled
should have
guilty
done
so
that.
long ago.
They
And
should
I
have
bet
gotten
you
a
he is
deal.
deteriorating
He
physically and
probably
everything else.
is.
Because have you heard him talk? I haven't heard him talk because guess who's not letting him talk? Guess who doesn't care about Richard Allen? His
Immense
attorneys.
pressure on him. That if he could just plead guilty and
know.
like move on with his life, albeit in prison. Yeah. Anyways. Yeah. Okay, let's see. Okay. Here you go, Alice. Hopefully this will be a little less dramatic.
That's a little scared of me right now.
This is from and they want to know, if given a choice, would you prefer a fresh baked bread with butter or any other topping, or a fresh baked hot apple crisp with ice cream?
Mine, I don't think you know this. It would be bread with butter.
Really?
Like a crispy. I just baked bread tonight and ate that exact thing, so it's on my mind. First of all, I'm not a huge apple crisp fan. I'm a huge chocolate fan, and I love ice cream. But something about like if you have a nice crispy sourdough bread and you like cut into it right out of the oven and it like flakes all over, and the butter just like melts on top. Oh, that's amazing.
Look, some things in life you need a lot of money to really enjoy, but many of the best things in life are the simple things. And if there's anything better than a fresh baked loaf of bread and some really good butter or olive oil, maybe with a little balsamic, I mean, it just
fresh cracked pepper in there.
Oh, and so yeah, there you go. Maybe a little salt. Oh, that's amazing. And it's like so simple. It's like simple things like, why don't we eat this more often? Why aren't we like the French and the Italians where they just like, I mean, they know how to live, man. Like, you
go just walk down the street with a baguette straight out of the oven.
Like, you wake up in the morning, like if you're in some little French town or some little Italian town, you wake up in the morning and there's some bakery that's open and they've made the bread. You go in and you get some bread, maybe some cheese, maybe some soft cheese. You want to bring cheese into this too? Like, yeah, it's just incredible. I mean,
and
hard
like,
to beat.
I really like Kerrygold. Is it Kerrygold? I don't know what it's called. The Kerrygold.
The Irish.
The butter.
Yes.
The butter tastes better. It really just tastes
It's
better.
so good.
So my same farmer that I get my meats from, he started to sell like raw milk, and I take the cream off the top, put that on butter, like put it on top of the bread. Oh my goodness. I'm not sure it's legal, but it's so yummy.
Yeah. I mean, yeah. So I am going to go with the bread as well, whether or not it be butter. I will say it would be a slightly more difficult question, though. I think I still would go bread if it was a peach cobbler and ice cream. Peach cobbler and ice cream is basically the most decadently delicious thing in the world. So that would have been a little harder than the apple crisp, but I just think the bread and the butter is just amazing. It's just so amazing.
I have fresh bread downstairs. Probably going to go eat some after this, now that you guys have inspired me to eat carbs at midnight.
All right. Well, there you go. We answered the question. Congratulations. We did it.
Sorry about that, Brett. Sorry, I really scared
We did it.
Part of it is I had told people in the chat that I had to yell today, no, that snake doesn't come in the house. That wasn't a hypothetical. It was like really something that came out of my mouth. The snake never came in my house, but the snake skin did.
Success.
So there's a snake skin sitting on top of my counter next to the fresh baked bread, which has kept me from eating the bread because I'm like, that's disgusting. But now I'm going to go eat the bread. So I'm a little amped up today, I don't know why.
There you go. All right. Well, You want to sign us off then, Alice, for real this time?
I'll sign us off. Well, guys, I hope you've enjoyed learning something new today. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
There you go. There you go. It's a little like a record scratch, like in the middle of the. Yeah. I bet you're wondering how I got in this situation.
Oh my
Like Alice,
gosh.
that's great.
Alice does
Okay.
great.
That was awesome.
That was great.